Welcome to this deep dive. You sent us a really comprehensive set of documents here.
Sure.
I mean, everything from audit and compliance manuals
Right.
to the EPF and pension schemes, recovery procedures, how employee info is handled. It's quite a stack.
Absolutely. We've got the audit manual, communication framework, compliance, exemption manuals, the EDLI and EPF schemes themselves, employee info booklet, FAQs, inspector manual, pension recovery manuals. Yeah, it's a really broad look at how the EPFO works.
So our goal here, our mission for this deep dive is basically to pull out the key insights from all this material for you. I want to give you a clear, concise understanding of how the employee's Provident Fund organization operates. You know, from internal checks to how they deal with employers and employees, audits, communication, compliance, exemptions, pensions, even recovering dues.
Yeah, the whole 9 yards.
Think of it as your fast track to getting really informed about the EPFO. Okay, let's dive in, starting with the audit functions.
Yeah, the audit manual seems like the logical place to start. The key thing here is it's all about uniformity, making sure all EPFO audits, statutory, external, internal, follow the same playbook.
Okay.
It's a training tool, helps with decision making, kind of a central rule book for audits.
Right, so consistency is key, making sure everyone's on the same page for accountability. And the audit division at the head office, they handle the big external ones, right? Like the CAG audits, the Controller and Auditor General of India.
Exactly. The HO audit division oversees those external statutory and CAG audits, and the manual really stresses sticking to timelines. There's actually a figure 7 in there that maps out some key deadlines.
Timeliness, yeah, super important. Nobody wants audits dragging on. Now, internal audits, what's the main purpose there, would you say?
Well, the core idea of internal audit in EPFO is providing an independent check on their own operations, administrative, financial, operational stuff. The goal: ensure financial accuracy, boost efficiency, and, make sure they're complying with all the rules for handling money, accounting, everything. Ultimately, it boils down to making sure EPFO follows the law, the regulations, and its own policies.
So it's like EPFO policing itself, making sure everything's running smoothly and by the book. How does that internal audit process actually kick off?
It's pretty structured. It starts with an audit calendar that involves the zonal offices and head office working together. Then, each zonal office sends out an audit planning memo for every office that's up for audit.
Got it.
These memos go to the internal audit parties, the IAPs, too. Based on that, the IAPs plan their audit, figure out travel, which documents they need to look at.
Okay, so a clear plan before they even show up.
Yep.
What happens when the auditors actually arrive in an office?
First thing is usually an entry conference with the office in charge, the OIC. It's basically a kickoff meeting.
Right.
Annexure 3 in the manual has a checklist for this meeting, key things the IAPs need to cover. They take minutes too, which becomes part of the audit file.
Good way to set expectations up front. Then the real work starts, digging into the records.
Exactly, that's the audit field work. The IAPs might issue preliminary audit memos, basically, initial findings or questions. The office being audited gets a chance to respond.
Okay.
And if the response is satisfactory, clears things up, then that memo doesn't become a formal audit para in the final report.
So minor things that get sorted quickly don't necessarily escalate.
Yeah.
But what if it does become an audit para? What makes a good draft audit report? The DRR.
Right. The DR needs to be really clear and accurate. Things like having precise headings for each point, making sure every observation gets its own unique number, no subpoints like 1A, 1B. Part 1 of the report, which lists old, unresolved issues, has to be spot on. And crucially, if the auditors decide an old issue is settled, they have to write down exactly why.
Okay, documented reasons.
Yeah. Plus, they need to return all the documents they borrowed promptly and record when they return them. And the language needs to be super clear, no jargon, no ambiguity. Points 3 to 8 in the manual really hammer this home. The main takeaway is precision and making it understandable.
Clarity and accuracy definitely sound crucial. What happens after that draft audit report goes out?
The head of the office that was inspected gets a month to send back detailed para-by-para replies on the final audit report to the Zonal Audit Committee. The manual also mentions a 5C framework in Figure 11 for writing these reports.
The 5C framework. Sounds important. What are the C's and why use it?
The 5 C's are clear, concise, cogent, complete, and correct. Basically, it's a guide to make sure audit reports are easy to understand, get straight to the point, are logical, cover everything needed, and are factually accurate.
Makes sense.
It's all about making the reports effective, something people can actually act on.
Absolutely. Now, the manual talks about core areas for internal audit. What's that about?
These core areas are specific functions in both field offices and the head office that internal audit really focuses on. The Internal Audit Division at HO reviews and updates this list every January, or more often if needed. What's significant is that this keeps the audits relevant, focused on the most critical parts of EPFO's operations, adapting to changes or new risks.
So they're constantly refining their focus. What about the Zonal Audit Committee? What do they do and what's their key power?
The Zonal Audit Committee, or ZAC, has the power to basically drop or close audit objections, paras, that are purely about procedural mistakes, as long as the financial value involved is up to 25 lakh rupees.
Oh, interesting. So they can resolve smaller procedural issues locally.
Exactly. It streamlines things. Their makeup varies slightly. For PDUNES, that's the training academy, the director heads it. For head office audits, it's the ACC audit.
Got it. Now, the manual mentions concurrent audit too. How's that different from the internal audits we've been discussing? What's the benefit?
Concurrent audit is more like a real-time check, mainly on financial transactions. The big benefit is catching errors or potential fraud as it happens, not after the fact.
Right. Proactive.
Yeah, and it helps improve processes immediately by finding weaknesses in internal controls. Figure 14 shows this. Unlike the periodic internal audits, concurrent is ongoing. That continuous monitoring is the key insight.
Like a constant financial watchdog. Where does this happen? Who's involved?
It happens across various EPFO offices and regions. The specific location depends on what's being monitored in real time. Stakeholders? Well, the staff whose work is being checked, the concurrent auditors themselves, and management who use the findings for quick improvements.
Makes sense. Let's circle back to the Internal Audit Division at head office. We know they define core areas and oversee external audits. What else falls under their umbrella?
They've got quite a few other key jobs. They make sure zonal offices issue the audit calendar on time and the planning memos for each RO. They're involved in auditor training, working with PDUNES. Crucially, they use audit findings to drive systemic improvements across EPFO finding areas needing reform. They also help shape policy, run audit meetings, coordinate with internal and external bodies, and manage the archive of all the final audit reports. They're really the central hub for internal audit.
Sounds like it. And the zonal offices. What's their role beyond the planning memos?
Zonal offices run the monthly Zonal Audit Committee meetings. They review the replies from regional offices to audit paras, and they can settle the ones within their financial authority.
Right, the procedural ones up to 25 lakhs.
Exactly. If needed, they ask the ROs for more info. Then, for the bigger issues, the Committee A and B paras, they send recommendations and their meeting minutes up to head office. They also report back to HO on any paras they dropped at the zonal level, so they're a vital middle layer.
A multi-level system with checks at each stage. The manual lists specific ROs under different audit parties, like Ahmedabad, Jaipur, Mumbai. Why detail that?
The main reason for listing which regional offices fall under which internal audit party IAP is just to clearly define who audits whom. It sets out the geographical responsibility for each team, prevents overlaps, ensures clear accountability.
Establishes accountability. Got it. And those annexures mentioned, 3rd to 6th, checklists for working files, exit conferences, draft reports. What's their purpose?
These checklists are basically practical tools to boost audit quality and consistency. They make sure auditors cover all the bases at each stage, from planning right through to the final report. Think of them as quality control for the audit itself.
Like a step-by-step guide for thoroughness. The manual even calls out specific things to check, like pending transfer-in cases, NEVFT rejections, pension cases, and defaulting establishments. Why these specific ones?
These are highlighted because they directly impact members. Pending transfers mean delays in updating accounts when someone changes jobs. NEVD rejections mean beneficiaries aren't getting their money.
Right, critical service delivery issues.
Exactly. And checking pension cases and defaulting establishments is vital for the integrity of the pension scheme itself. So the focus is clearly on areas that directly affect members.
Those examples really drive home the practical impact. Lastly, on audits, the head of the internal audit team, what are their key responsibilities?
The team leader has important duties. They prepare the list of documents needed for the audit based on the zonal office memo and send it off. They also work closely with their team to finalize the audit strategy, aligning it with the objectives and scopes set out in that planning memo. Their leadership ensures the audit is organized, focused, and effective.
Okay, so the audit function is definitely detailed, multi-layered, focusing on accountability. Let's shift gears now. Communication. How does EPFO approach that based on the communication framework?
The communication framework really emphasizes two key things: strong internal cohesion among employees, and solid external relationships with everyone else, employers, employees, public. The key insight is it provides a blueprint for communication that's consistent, timely, and purposeful. EPFO sees this as absolutely essential for hitting their goals and just being effective today. It's about aiming for excellence in how they communicate.
Sounds like they get that clear communication is vital. What channels do they use internally to keep employees informed?
They use a mix. Emails for general updates, the e-office notice board for important internal stuff, training sessions online and in person for development and policy updates, formal circulars and manuals for detailed guidance, and SOPs, standard operating procedures, for step-by-step task instructions. It's a multi-channel approach.
A mix of digital and formal methods keeps everyone in the loop. Now, externally, Nidhi-Apke-Nikkat 2.0. That sounds like a big deal. What's the main goal there?
Nidhi-Apke-Nikkat 2.0, or NAN 2.0, is really about boosting EPFO's presence everywhere, in every district. It's designed as a more inclusive outreach program.
More inclusive than before.
Yeah, previously stakeholders could connect on the 10th of the month at ROs, but NAN 2.0 aims for wider reach, stronger district focus. The key idea is making it a platform for everyone, employees for grievance redressal, information sharing, making EPFO more accessible at the grassroots.
Getting down to the local level, how often do these NAN 2.0 events happen?
They happen on the 27th of every month, started back in January 2023. If the 27th is a holiday, it's the next working day. And they really stress holding these camps in easy-to-reach locations to get maximum participation.
Accessibility is definitely key. Are there specific themes for these events?
Yes, the publicity division at head office sets monthly themes quarterly. They send these out to all the zonal and regional offices so they can focus on those topics during their NAN 2.0 activities. Ensures consistent messaging across the country.
Smart way to keep everyone focused. What about the look and feel of these camps? How do they present info?
The framework says teams should use the official standees and banners prominently. Digital displays are preferred, but physical ones are used too. If they use regional languages, the fonts must be clear, keeping the original design, and placed where people will definitely see them.
Clear info in local languages, vital for reaching everyone. The framework mentions social media used by head office too. How are they using that?
Head office uses social media actively for important updates. They use things like infographics, cartoon strips, GIFs, videos, engaging formats.
Makes sense.
The benefit is making complex info easier to digest and share, reaching a wider audience, making things more accessible.
A modern approach. Beyond the regular NAN 2.0, what other outreach efforts are mentioned?
Yeah, they really push for NAN 2.0 camps in accessible spots, specifically mentioning aspirational and border districts to reach underserved areas.
Good focus.
Other things include webinars, district-level camps, keeping the EPFO directory updated, ICE activities, that's information, education, communication, creating video clips, using MyGov and social media for quizzes, and getting content for their quarterly newsletter. It's a very comprehensive multi-channel strategy.
Sounds like they're using every tool in the box. What's the main takeaway from this communication framework for you?
The big takeaway is that EPFO truly believes communication is the organization's lifeblood. It's essential for that two-way flow of accurate, accessible information. They seem really committed to high service standards through good communication.
Makes perfect sense. Okay, let's move into the procedural side. Compliance and legal procedures from the compliance manual. What happens first when an inspection report comes in?
The compliance manual lays out the process. It starts with an inspection report, triggering the creation of an e-office compliance file for that specific establishment.
Okay, digital from the start.
Right. This file then goes to the section supervisor, the SSSSA in charge, who needs to review it and pass it on to the circle officer within 2 working days. Figure 5 in the manual actually shows this workflow. The key thing is that digital time-bound process right away.
So it all starts with that report in the e-office. What goes into those e-office proceeding files if an inquiry is formally started?
That separate e-office file for proceedings will contain the diary number generated on the e-proceedings portal for that inquiry. A draft summons, Form ST4, gives a template and the enforcement officer's investigation report, plus any other documents that form the basis for starting the inquiry. Keeps everything documented.
The summons sounds like a critical first legal step.
Yeah.
What are the rules around issuing a summons or notice?
The manual is very clear. Issuing a summons or notice is absolutely essential to start any legal proceeding. And the officer initiating an inquiry under Section 7A must have written reasons showing a prima facie case exists.
Prima facie, so some initial evidence.
Exactly. Some credible indication of a default, evasion, or a real dispute about whether the act applies. Just starting an inquiry without that is considered a fishing expedition, and that's not allowed. And a complaint received, that's just info, a potential lead, not prima facie evidence by itself. So you need solid grounds first.
Need documented grounds before kicking off a formal inquiry. Who actually has the authority to start these inquiries? Does it vary?
Yes, it depends on the size of the establishment, measured by the number of contributory UAN's universal account numbers. Page 250 has a table.
Okay.
For smaller places, say up to 250 UANs, an assistant PF commissioner, APFC, might initiate, but it'd be reviewed by another APFC or an RPFC2 regional PF commissioner grade 2. For large ones, over 1,000 UANs, it's usually an RPFC2 or the officer in charge at the regional office with review by an RPFCI or the divisional office OIC.
Right.
And if an establishment files multiple ECRs, the electronic returns for 1 month, you add up the UANs across all of them to determine the right authority. It's a tiered system based on size.
Makes sense. Bigger companies get higher level scrutiny. The manual mentions Section 7C2 about redetermining escaped amounts. What's that about? Any safeguards?
Section 7C is a mechanism to go back and assess any contributions or dues that were missed the first time around. But, and this is a key safeguard, they can't just issue an order for this escaped amount without first giving the employer a reasonable chance to present their side of the story.
So natural justice applies.
Absolutely. And higher level officers doing supervisory checks can also tell the original assessing officer to use Section 7C if they think something was missed. It's another layer of checks for accuracy.
Checks at multiple levels, and the employer gets hurt. What about the orders themselves under Section 7A and 7B? What do they need to include to be legally sound?
These orders have a specific structure. They need to summarize what all parties submitted, clearly state the issues being decided, provide a detailed analysis of the facts and evidence leading to the findings, and then state the actual order being passed.
Very structured.
Yeah, it ensures transparency and clear reasoning for the decision, whether they're accepting or rejecting arguments from the establishment, the departmental representative, or any complainant involved.
That sounds legally robust.
Yeah.
Now, what if employers are late paying their dues? The manual mentions automatic calculation of damages and interest. How does that work?
Right. If an employer pays late via the unified portal, the system automatically calculates the damages under Section 14B and the interest under Section 7Q for the delay period.
Okay.
Then, the employer gets an option right there on the portal to generate a challan and pay that calculated amount online. It's designed to streamline things and ensure penalties are consistently applied.
The system flags and calculates it automatically. What if the employer still doesn't pay that auto-calculated amount? What happens then?
If they don't pay on time and ignore the auto-calculated damages and interest, the system automatically triggers the process for further legal action. It escalates things to ensure compliance and recovery of everything owed, including those damages and interest. There are protocols for this escalation.
And are there other penalties for employers who default, especially on the employee share they've already deducted?
Yes, Section 14 deals with that specifically. If an employer deducts the employee's contribution but doesn't remit it, the penalties can be serious imprisonment for at least a year, plus a fine of 10,000 rupees.
Wow. Okay.
And Sections 14, 1A, and 1B cover other violations of the act or scheme, which can also lead to imprisonment, at least 6 months, and fines, 5,000 rupees, though courts can impose lesser penalties if there are special recorded reasons. These are strong deterrents.
Significant penalties, definitely aimed at protecting employees. The manual mentions limitation periods from the Code of Criminal Procedure. How do those apply here?
Section 468 of the CRPC sets time limits for prosecuting offenses based on the punishment. For offenses punishable up to 1 year in prison, the limit is 1 year. If the punishment is between 1 and 3 years, the limit is 3 years. But Section 472 defines a continuing offense. Many EPFO defaults, like constantly failing to pay contributions, are seen as continuing offenses. For these, a fresh limitation period starts every moment the offense continues. That's crucial for ongoing non-compliance.
So the clock keeps resetting for ongoing issues. What about withdrawing a prosecution that's already started? Can that happen?
Yes, there's a provision. If an employer, after an FIR is filed, quickly pays all the outstanding dues, say within 15 days to a month, and shows they're complying consistently after that, a proposal can be made to withdraw the prosecution.
Right.
This proposal goes up to the Central Provident Fund Commissioner, the CPFC, for approval. If the CPFC agrees, they inform the state authorities that the EPFO, as the complainant, has no objection to dropping the case. It encourages quick correction of defaults.
Seems pragmatic. Encourage compliance without maybe dragging every case through court. The manual briefly mentioned Section 110 of the CRPC. What's that about in this context?
Section 110 deals with requiring security for good behavior from habitual offenders. The compliance manual mentions it, but doesn't go into great detail on how often it's used specifically for EPFO compliance. It's generally a preventative measure against repeat offenders.
Understood. Now, with insolvency proceedings becoming more common, how does EPFO handle recovering dues from companies going through CRAP under the Insolvency and Bankruptcy Code, the IBC?
EPFO really stresses being proactive here. They try to assess and recover dues before formal IBC proceedings even start. They recognize they need to understand the CRP process under the IBC really well.
Makes sense.
To make the most of that window between a company filing for insolvency and the resolution process kicking off. Sections 18, 25, 30, 36, 42, 65 of the IBC are key, and officers need to know them inside out to effectively represent PF members' interests before the adjudicating authority.
So a proactive and informed approach to protect members' funds during IBC. The manual distinguishes between routine inspection and physical inspection. Yeah, it's the difference.
A routine inspection is usually scheduled, maybe based on risk assessment more planned. A physical inspection, though, seems to be for situations needing immediate on-site action.
Like responding to a complaint.
Exactly. Maybe a credible complaint about a serious issue, or other signs needing urgent verification, perhaps without the usual prior notice or nudging the establishment first. Speed and immediate verification are the key differences.
Planned versus immediate reaction. What are the timelines for assigning and completing inspections and then starting assessment if needed?
The RPFC in charge assigns inspections of non-compliant establishments via the SHRAM Suvita portal, SSP, stating the reasons. Ideally, assigning and completing the inspection should happen within 7 working days total.
Okay, pretty quick.
Then, once the RO gets the report, the compliance circle officer decides if an inquiry is needed to assess dues. If yes, the RPFC has to assign the assessment proceedings within 3 working days of receiving the inspection report.
Wow, that's fast.
Yeah, and the inquiry itself should be fast-tracked. Special recovery certificates need to be issued the same day the final order is uploaded, and the zonal office needs to know about that certificate within 3 working days. Very tight timelines, pushing for swift action.
Definitely sounds like a push for speed.
Yeah.
The manual lists examples of covered industries: indigo, lac, gold mines, hotels, banks. Why provide this list?
Listing these industries with their schedule numbers and effective dates under the Act is really about clarity. It helps define the scope of the EPF Act in a practical way.
Right. Shows who's covered and since when.
Exactly. It's a reference point for determining if an establishment legally has to comply. Clear guidance for everyone.
Makes sense. Lastly, on compliance, the manual references specific guidelines and circulars on Section 7A proceedings, multi-location compliance, damages, email notices. Why reference these extra documents?
Referencing these specific guidelines and circulars is crucial because they provide the detailed operational instructions and official interpretations of the law. They ensure EPFO officers follow consistent, legally sound procedures when conducting inquiries, levying penalties, or communicating with defaulting establishments. They keep the operational side aligned with the latest official guidance.
So they keep procedures updated and legally accurate. Okay, let's shift focus to the employee's deposit-linked insurance EDLI scheme. What are the foundational basics here?
First off, really important, employees don't contribute to the EDLI insurance fund. It's funded entirely by employers.
Okay, fully employer funded.
Right. They pay 0.5% of the employee's basic wages and dearness allowance monthly. So it's a safety net for employees' families, paid for by the employer.
And what benefits are paid if an employee dies while in service?
If an employee who's a member of the PF, either the main scheme or an exempted one, passes away, the people entitled to their PF balance also get the EDLI benefit. The amount is set out in paragraphs 22.1, 22.3, and 22.4 of the EDLI scheme. And it's significant that these benefits were increased quite a bit from April 28, 2021. Paragraph 22.4 actually adds an extra 20% on top of the benefits calculated under the other subparagraphs. Provides a much stronger safety net now.
Those increases must make a real difference. What if employers are late sending in their EDLI contributions? Are there penalties?
Yes, absolutely. If employers delay their insurance fund contributions, the CPFC or an authorized officer can recover damages under Section 14B of the Maine Act, read with Para 8A of the EDLI scheme.
Okay.
The damage rate depends on how long the delay is. The manual has a table showing the percentages. For instance, less than 2 months late. That's 5% per annum on the outstanding amount. It's a clear financial incentive to pay on time.
Financial disincentives, right.
Yeah.
How is the money in the insurance fund managed and invested?
The funds collected are invested according to the pattern set out in paragraph 52 of the Maine EPF scheme, 1952. This pattern was notified back in April 1997.
And what kind of investments are allowed under that pattern?
It's fairly broad. Government securities, treasury bills, bonds from public sector undertakings, PSUs, Basel III Tier I bonds from banks with certain limits and conditions, like being listed,
Okay.
and also units of Category I and II alternative investment funds, AIFs, regulated by SEBI, again subject to conditions and credit ratings. For PSU bonds and AIF units, the credit rating needed is tied to the sponsor's rating, and if there are multiple ratings, they use the 2 lowest ones for compliance. It's about diversifying to balance safety and returns.
A managed mix of secure and potentially higher yield investments within rules.
Yeah.
How is the actual EDLI assurance benefit calculated?
It depends mainly on how long the employee worked. Paras 22 and 22.3 explain it. If someone worked continuously for the same employer for 12 months before death, the benefit is 30 times their average monthly wage, up to the Rs. 15,000 ceiling for those 12 months, PLUS 50% of their average PF balance, subject to the overall maximum in Para 22.1.
Okay, complex calculation.
It can be. Para 22.2 also has an alternative calculation based on employment duration. For example, if the average PF balance was 50K or less, the EDLI benefit was twice that amount. If over 50K, there was a formula with base amount plus a percentage of the excess. But crucially, remember Para 22 from April 2021 adds that extra 20% on top of whatever these calculations yield, so the current benefit is higher.
Takes into account wages and PF balance with that recent boost. The manual talks about monitoring EDLI exemption applications and renewals. What does that involve?
The monitoring aims for timely handling of several things. Tracking exemption applications, making sure group insurance policies, used alternatives, are renewed on time, checking Form 7IF submissions are punctual, and ensuring inspection charges are paid.
Right.
It involves the section supervisor reviewing incoming mail, handing it off to the right person with dated initials for tracking. New exemption applications get logged in a register, and ROs need to check if all branches of an establishment seeking exemption should be covered. It's about preventing delays and ensuring compliance.
A detailed tracking system. Annexure 3 provides a format for exemption proposals under Section 17.2a. What key info goes in that proposal?
Annexure 3 lays out the format for proposing an EDLI exemption under Section 17.2a. It needs the establishment's full name and address. It's addressed to the CPFC but goes through the local RPFC.
Okay.
It has to clearly state it's an application for EDLI exemption under that section, and the employer, the proposer, needs to provide their full name and address too. Standardizes the initial details needed.
Standard format ensures all basics are covered. The manual includes a calculation example for someone named Rahachio HPS, so a point of showing that.
That example for head HPS is there to show the step-by-step calculation in a real scenario. It uses his actual PF balance growth and average wages.
Makes it concrete.
Exactly. It walked through applying the EDLI formulas, considering both PF balance and wages, applying the minimums, maximums, and importantly, showing the impact of that extra assurance benefit percentage. Makes the whole process much clearer and easier to grasp.
Seeing the numbers definitely helps clarify things. Okay, let's move to the Core Employees Provident Fund Scheme, the EPF scheme, 1952 itself. What are the fundamental aspects?
Well, the official title is the Employees Provident Fund Scheme, 1952. Chapter 1 covers the basics title, application to different establishments once they qualify. Chapter 2 sets up the key governing bodies, the Board of Trustees, the Executive Committee, and the Regional Committees. These are central to running the whole scheme.
These bodies are obviously crucial for managing such a huge fund. What about withdrawals and advances from members' PF accounts? The outline mentioned house purchase in special cases.
Right. Paragraph 68BD deals specifically with withdrawals and financing for buying or building a house. And then paragraph 68H, J, K, and L cover non-refundable advances for special situations.
Like what kind of situations?
things like a factory lockout or closure, illness, marriage, or higher education for children, and even abnormal conditions like natural disasters affecting the member. They provide financial support during specific needs or hardships.
Important support in tough times. The scheme document lists industries and the dates they were covered. Why keep that historical record?
Listing industries like coffee curing, biscuit making, road transport, paint, bone crushing, etc., with their effective dates, establishes a clear timeline of the scheme's expansion.
Tracks its growth.
Yeah, it serves as a key reference for determining exactly when a specific establishment came under the obligation to comply with the EPF Act and scheme, crucial for jurisdiction and enforcement.
Provides essential history. We touched on regional committees before. What's their main function under the EPF scheme?
Paragraph 4 outlines the Regional Committee. It's primarily an advisory body to the main Central Board of Trustees, CBT. It includes employer, employee, and government reps from the region.
Okay.
Their job, per Para 4.2, is to advise the Central Board on matters referred to them, and generally on administering the scheme within their state or region. They provide feedback on things like contribution collection, recovery progress, claim settlement speed, and ways to improve efficiency locally.
So, a vital local link, providing feedback upwards. The scheme also lists reasons someone might be disqualified from being a trustee or on a regional committee. What are some key disqualifiers?
Paragraph 8 lists several grounds. Being declared of unsound mind by a court, being an undischarged insolvent, bankrupt, being convicted of an offense involving moral turpitude,
Right.
or, if they're an employer, defaulting on payments due to the board or the fund. These criteria aim to ensure the integrity of these governing bodies.
Seems reasonable to ensure integrity. What if a trustee appoints a substitute for a meeting? Are they still liable?
Yes, absolutely. Paragraph 14.3 is clear. Even if a trustee sends a substitute, the original trustee remains fully liable for any misappropriation or misapplication of the fund by that substitute.
Okay.
And they're also liable for any misfeasance, doing something lawful wrongly, or nonfeasance, failing to do something required, by the substitute regarding the fund's management. Responsibility stays with the appointer.
Responsibility stays put. How are decisions made in meetings of the Central Board, Executive Committee, or regional committees?
Paragraph 15 says decisions are by a simple majority vote of those present and voting. If there's a tie, the chairman gets a casting vote to break the deadlock.
Standard majority rule.
Mostly. There's also a provision where the chairman can decide an issue by circulating papers to all members in India and getting written opinions. Then, the majority written opinion decides it. If that's tied, the chairman's own opinion breaks the tie.
Interesting alternative. The scheme details the appointment and powers of key officials, like the Central PF Commissioner and the Financial Advisor and Chief Accounts Officer. Any notable restrictions on them?
Paragraph 19 has an important point. Neither the CPFC nor the FANCAO can take on any work unrelated to their official duties without getting specific sanction from the central government.
Underscores their focus.
Exactly. And paragraph 21 gives the central board the authority to open regional and local offices as needed and define what they do, sets up the operational structure.
Makes sense for nationwide implementation. How do employees of exempted establishments or new joiners in covered ones actually become members of the fund?
Paragraph 26 covers this. Generally, any employee in a covered establishment is a member from day one. For those in establishments that get exempted later, if they were already in a recognized private fund, they might stay there. Importantly, Para 26 allows an officer, APFC rank or above, to enroll someone or let them contribute above the wage ceiling based on a joint request from the employee and employer.
Flexibility there.
Yes, provided the employer agrees to pay the admin charges on the higher amount and comply with all other rules for that employee. Offers some flexibility.
Good to know. What conditions does an establishment need to meet to get an exemption in the first place?
Paragraph 27 details this. The fundamental rule is that the overall benefits the establishment provides, PF, gratuity, pension combined, must not be less favorable than what the EPF Act and scheme offer.
That's the benchmark.
Right. Plus, Para 27.2 lists ongoing obligations for exempted employers. Maintain proper accounts, submit returns on time, allow inspections and pay charges, invest PF collections according to government directions. Also, Para 27.9 says their contribution and interest rates can't be lower than those declared under the main EPF scheme. And Para 27.10 ensures that any beneficial amendments to the main scheme automatically apply to exempted establishments too, even while their own rules are being updated. keeps employees protected.
Very clear that exempted places still have strict rules ensuring employee benefits are protected. What about their specific duties for record keeping and investing the funds?
Paragraph 28 mandates exempted employers keep detailed member records, contributions, withdrawals, interest. Electronic format is encouraged. They also have to give annual statements or passbooks to employees free of charge.
Okay.
For investments, paragraph 29 is key. Securities must be held in the trust's name, preferably in DMAT form. The trustees maintain a register, ensure interest is credited promptly, use approved depository participants, and inform the RPFC about their arrangements.
Sounds tightly controlled.
It is. Para 2920 even says they need RPFC approval to raise funds for obligatory expenses like claim settlements or advances. Strict guidelines ensure fund security.
Strict controls indeed. What if an exempted employer fails to pay contributions on time? What action can EPFO take?
Paragraph 32A addresses that directly. If an exempted employer defaults on contributions or transfers, the CPFC or an authorized officer can recover damages from them as a penalty. The rates are defined in that paragraph. So even exempted employers face financial penalties for non-compliance.
Accountability applies across the board. What forms do employees and employers use for declarations and providing essential info?
Paragraph 34 says employees use Form 11 for personal and employment details, including info needed for the pension scheme. Employers use a specified format, para 36, for consolidated returns within 15 days of scheme commencement.
Okay.
And paragraph 36A mandates employers use Form 5A to provide ownership details, branches, owner names, directors, partners who's in ultimate control. Crucially, they must report any changes in ownership within 15 days. These forms maintain an up-to-date database.
Standard forms for accurate data. Does the scheme outline the budget process for the Central Board of Trustees?
Yes, paragraph 58 details it. The CPFC prepares an annual budget, the Central Board approves it, and then it goes to the central government for final sanction.
Multi-level approval.
Right. There's also a process for supplementary budgets for unexpected costs. And any spending beyond the sanctioned budget must be reported ASE to the board to get ex post facto sanction from the government, ensures robust financial oversight.
Clear financial oversight. The scheme mentions financing insurance policies via PF accounts. What are the conditions for that?
Paragraph 61 allows it, but with conditions. The policy must be assigned to and delivered to the central board. If these conditions aren't met or the policy lapses, any PF money paid towards it, plus interest, must be repaid to the fund.
A safeguard mechanism.
Yes, and the scheme allows the employer to deduct the repayment from future wages if the member doesn't pay it back directly. Protects the fund's integrity.
Sensible protection. We talked about house purchase withdrawals, Para 68 BD. Are there limits on how that money is paid out?
Yes, Para 68 BD2 says the withdrawn amount usually isn't paid directly to the member. It typically goes straight to the government or housing agency in installments as the member authorizes.
Okay.
Para 68 BD3 limits further withdrawals for the same purpose if a previous housing loan hasn't been fully repaid. And Para 68 BD4 requires the member to refund any excess amount withdrawn if it exceeds the actual cost within 30 days of finishing the purchase or construction. Ensures funds are used as intended.
Conditions make sense to ensure proper use. We also touched on non-refundable advances for special cases like factory closure. What are the eligibility conditions?
For advances due to hardship like lockout or closure or non-receipt of wages, Para 68H, the member needs at least 7 years of membership and a minimum balance of Rs 1,000 in their own share plus interest. Generally, only 3 such advances are allowed per member.
Okay.
For advances in abnormal conditions like natural calamities, Para 68L, the advance is limited to the lesser of Rs, 5,000 or 50% of their own contributions plus interest. Conditions ensure it goes to those with real need and sufficient PF stake.
Provides crucial relief in tough times. What's the process for claiming PF benefits if a member passes away? What are the claimants' and employers' roles?
Paragraph 70 outlines this. When an application for the deceased member's PF is received, the employer must forward it to the RPFC, or authorized officer, immediately, definitely within 5 days.
Employer has a key role.
Yes. If the claimant can't go through the employer, they can send it directly to the RPFC. The RPFC might then send it to the last employer for verification. The employer must return such forwarded claims within 5 days with necessary info. Timely action and cooperation are vital here.
Speed and employer cooperation are key. We discussed the Maine EPF Board of Trustees. Are there similar guidelines for the trustees of exempted establishments?
Yes, paragraph 76 deals with the constitution and functions of the Board of Trustees for exempted establishments. The employer nominates a representative as chairman, who usually gets a casting vote in case of ties. The standard term for these trustees is 5 years, and they're generally eligible for reappointment. Provides a structured governance framework for these private funds, too.
Similar structure, tailored for exempted entities. Finally, this scheme mentions resolving doubts about membership eligibility and special rules for scene workers. Can you touch on those?
Paragraph 26B handles doubts about whether, say, a newspaper employee is eligible for membership or their start date. The matter goes to the jurisdictional RPFC, who holds a hearing with both employer and employee before deciding, a formal dispute resolution mechanism.
Got it.
For scene workers, defined under a specific 1981 Act, the EPF scheme has special modifications towards the end. These account for the irregular nature of film industry work, like basing membership on completing work in a minimum number of films, not just continuous employment. Acknowledges sector-specific patterns.
Very comprehensive scheme addressing many scenarios. Let's turn to employee information and grievance redressal based on the employee info booklet and FAQs.
The employee information booklet really pushes the mandatory e-nomination process. It's Aadhaar-based now, uses Form 2 online. Members can securely designate nominees for PF and pension benefits this way, much simpler than the old paper forms.
Digital nomination definitely sounds easier. The booklet also helps with common tech issues, like resetting passwords on the unified portal. What's the guidance there?
It gives step-by-step instructions. If you forget your password, click Forgot Password on the login page, enter your UAN and the COPTCHA code.
Standard stuff.
Right. An OTP goes to your registered mobile. Enter that OTP and you can set a new password. Now, Q.34 in the FAQs covers the tricky bit. What if your registered mobile number has changed?
Oh, yeah, that happens.
So after entering UAN and COPTCHA, it asks if the OTP should go to the registered number or a new one. If you choose new number, you enter basic details, name, DOB, gender. If they match, you enter your Aadhaar or PAN. If that verifies against the database, then you can enter your new mobile number.
Multi-factor verification.
Exactly. An OTP goes to the new number. Verify that, and finally, you can reset your password. Ensure security even if the phone number changed.
Helpful process for a common problem. What about just viewing or downloading your UAN card?
Q.38 explains that. Log in to the unified portal with UAN and password. Go to the download menu. Select Download UAN card. It generates a PDF you can save or print. Convenient access to that key info.
Easy access is essential. The booklet says passbooks might not be available for employees in certain places. When does that happen?
Q.39 clarifies. If you work for an exempted establishment, your PF passbook generally won't be on the unified portal.
Okay.
Because the employer manages their own trust, you need to contact your employer directly for your PF statement. Important distinction for those employees.
Good to know where to look. Lastly on this, what if a member finds out they have 2 UANs? That sounds confusing.
Q.40 addresses that. It can happen sometimes, maybe due to incorrect exit dates filed by a previous employer or issues with transfer requests. If you find you have 2 UANs, report it immediately to your current employer. Also, send an email to epfo@unepf@epfindia.gov.in mentioning both your current and previous UANs. EPFO will verify, block the incorrect UAN, and keep the current one active, consolidating everything. Timely reporting is key to fix it.
Crucial advice for a potentially messy situation. Let's delve into exemption management now from the exemption manual. Seems there have been historical changes to the law around exemptions?
Yes, the manual highlights key amendments to Section 17 of the Maine EPF Act. In 1995, after the pension scheme started, pension replaced family pension in Section 17.
Right.
Then in 1996, Section 17.5 was amended regarding the transfer of the employer's share of forfeited PF contributions for employees leaving before full vesting. A significant change.
Okay.
Also in 96, Section 17.1c was amended to allow exemptions specifically from the new pension scheme, EPS 1995, for certain establishments. Shows how the law evolved with new schemes.
Shows adaptation over time. Does the exemption manual define employer and employee differently than the Maine Act?
No, it clarifies that the standard definitions from Section 2E for employer and Section 2F for employee in the Maine EPF Act apply here too. Employer is basically the one with ultimate control, and employee is anyone employed for wages in connection with the establishment. No special definitions for exemptions.
Standard definitions apply. What are the main conditions for getting an exemption in the first place?
The core condition is that the overall benefits provided by the establishment, PF, pension, gratuity, or contribution rate, must not be inferior or less favorable compared to what EPFO provides under the main scheme.
That's the baseline.
Exactly. Plus, they must strictly follow all the conditions listed in Appendix A to Para 27A of the EPF scheme, and comply with any other directions EPFO issues later. Ensures employees in exempted places get comparable or better benefits.
So employees shouldn't be worse off. The manual distinguishes between exempting a whole establishment versus just a class of employees. How are these different legally?
Exempting the whole establishment falls under Section 17(1) of the Act and Para 27A of the scheme. It takes the entire place out of direct EPFO coverage. Exempting just a specific class of employees is under Section 17(2).
Okay.
Para 27 of the scheme also covers exempting a single employee in limited cases by the RPFC. But any exemption, whole or partial, must meet the overarching conditions in Sections 17(1)A and 17th of the Act, different legal paths depending on the scope.
Different rules for different scopes. What roles do the regional office, RO, and zonal office, ZO, play in processing exemption applications?
Applications usually land at the jurisdictional RO first. The RO scrutinizes the application and documents. If they think it meets the criteria prima facie benefits aren't less favorable, they prepare a draft proposal for exemption.
Okay.
This draft proposal then goes up to the zonal office, ZO. The ZO reviews it, adds their own recommendations, and then forwards the whole package to head office for the final decision. The zonal ACC often plays a key role in this review. It's a tiered review process.
Multi-layered review with checks. What's head office's role in overseeing exemptions once they're granted?
Head office has a crucial oversight role. They monitor zonal offices based on how timely they complete compliance audits of exempted establishments and how punctually those establishments file their online returns.
Monitoring compliance.
Yes. HO also runs national outreach programs about exemptions, educating staff and stakeholders, and they lead capacity building efforts so EPFO personnel can manage the exemption process effectively. They provide strategic direction and overall supervision.
Comprehensive oversight. What are the ongoing duties of an establishment after it gets an exemption?
Once exempted, they have ongoing responsibilities. First, strictly adhere to all conditions of their exemption. Second, file all required returns accurately and on time. Third, properly manage their board of trustees for their private fund. And fourth, invest their PF collections strictly according to government directives. These are crucial for keeping their exemption valid.
Continuous obligation to maintain standards. What if an exempted establishment wants to get a cancellation of its exemption withdrawn? How does that work?
They need to inform the jurisdictional RPFC well in advance. The process depends on why it was canceled. If it involved breaking investment rules, Condition 29 of Appendix A, a mandatory third-party audit needs completing by December 31st of the fiscal year before the withdrawal date.
Okay, specific audit requirement.
If cancellation was for other reasons, the audit needs completing within 2 months of Form CE-10, a cancellation-related notice, being issued. In either case, the draft agenda sent to HO for withdrawal approval must include this third-party audit report. Ensures an independent check before reversing a cancellation.
Audits are key before reversing cancellation. The manual mentions court cases like Huli Mills and Gulshan Kansari Udyog related to exemptions. Why include these?
These cases provide important legal interpretations. Huli Mills, decided by the Supreme Court, confirmed that damages under Section 14B do apply to exempted trusts for non-compliance, overturning a high court view.
Clarified the law.
Right. Gulshan Kansari Udyog reinforces the principle that exempted employers must provide benefits no less favorable than EPFOs. Referencing these cases gives essential legal context and shows how rules are applied and interpreted by courts. Important guidance for everyone.
Legal precedents provide crucial context. What role does the main Central Board of Trustees, CBT, play in the exemption process?
The CBT plays a significant role. The law, proviso to Section 17, requires the CBT be consulted before the government grants any initial exemption, ensures their expertise is considered.
Statutory consultation.
Yes. Also, all cases of cancellation or voluntary surrender of exemption must go to the CBT for approval. Typically, the Exempted Establishments Committee, a CBT, reviews a report from the RPFC, vetted by ZO and HO first. The CBT's recommendation then goes to the government, which makes the final decision. CBT provides vital oversight.
Key oversight and approval role. The manual outlines timelines and responsibilities for different exemption actions: cancellation, management, granting, reverting to unexempted. Why define these so clearly?
Having clear timelines and responsibilities for cancellation, regulation, granting, reversion, etc. is essential for efficiency, transparency, and accountability.
Makes sense.
It sets expectations for everyone, establishments, EPFO offices, government authorities, minimizes delays, and ensures clear accountability at each step. Streamlines the whole exemption framework.
Clarity promotes efficiency. What key details does an establishment need to provide in its exemption application?
They need to provide quite a bit. Full address, branch details, addresses, employee counts, employer's name, email, mobile number, the date they were covered by the EPF Act, their PF code, total employee numbers, sometimes split by Aadhaar seating status,
Okay.
and full details of their PF trust name, PAN, address. All this info is needed for EPFO to properly evaluate the application.
Thorough info needed for assessment. The manual lists the conditions from Appendix A to Para 27AA. What are some key conditions exempted places must follow?
Appendix A has critical conditions. Key ones include establishing a proper board of trustees, chaired by employer rep, to manage the fund per government CPFC directions. The PF assets vest in this board, which is liable for proper management.
Right.
Others include strictly investing funds per government patterns, timely submission of all returns, physical and electronic, annual audit by a chartered accountant, and a formal undertaking by employer and trustees to transfer funds seamlessly to EPFO if the exemption is ever canceled, all aimed at protecting employee interests.
Safeguards for employee funds and compliance. The manual includes checklists for scrutinizing exemption proposals and for the annual review of exempted places. What do these checklists cover?
The initial scrutiny checklists cover establishment and trust details, a comparative benefit analysis to ensure they're not less favorable, necessary undertakings, financial soundness checks, and reviews of past audit reports.
Thorough initial check.
Yeah. The annual review checklists focus on ongoing compliance, adhering to investment patterns, claim settlement efficiency, checking for unauthorized investments, verifying interest rates credited must be EPFO rate, admin charges levied, and any outstanding audit issues. Both are crucial tools for evaluation and monitoring.
Detailed checklists ensure consistency. There's even a template, Form CE2, for the RO to propose canceling an exemption to the EC. What typically triggers such a proposal?
That template usually cites the establishment's failure to consistently follow the conditions imposed when the exemption was first granted. The legal basis is often Section 17.1 or Para 27A, leveraging Section 17.4, which allows withdrawal if conditions aren't met without reasonable cause. So persistent failure to meet the standards is the key trigger.
Consequence of not meeting standards. What documents are needed for proposals to cancel or surrender an exemption?
For cancellation, typically the original exemption notification if available, any orders relaxing withdrawing conditions, and an RPFC report on the trust's current financial health and compliance. For voluntary surrender, similar documents, plus the establishment's formal request stating reasons, details of PF funds transferred to EPFO, and often a recent third-party audit report confirming the trust status up to surrender. There's even a template for the RPFC's certificate on the trust's financial health at surrender. Ensures a clear record.
Comprehensive documentation for any status change. Finally, the manual lists relevant circulars and guidelines on exemptions. Why include those references?
Including references to circulars, like those from 2007, 2008, 2009, provides access to more detailed operational instructions, clarifications, and interpretations beyond the main act and scheme.
Fills in the operational gaps.
Exactly. They address specific procedural issues, interpret rules, or give new directives. Ensures staff and stakeholders are aware of current procedures and best practices in exemption management, a central reference for up-to-date guidance.
Vital for staying current. Let's shift to the inspector-cum-facilitator role based on their manual. Sounds like a dual focus.
That's right. The manual stresses their code of conduct, ethical standards, professionalism. It also notes their job descriptions need periodic review. Section 13 of the main act empowers them to carry out their duties. That legal backing is key.
Statutory authority. The manual mentions their role as departmental representative, DRAR, in inquiries. What does that mean practically?
As the DR, the inspector-cum-facilitator represents EPFO in quasi-judicial or legal proceedings under the Act. Their engagement, legal understanding, and ethics are crucial to protect the interests of employees and establishments involved. They present EPFO's side of things.
A key representational role. The manual stresses liaison with other government departments. Why is that important?
Strong liaison with departments like labor, industries, etc. keeps the inspector informed about local activities, trends, developments. Figure 17 lists info the district nodal officer, DNO, should share and seek.
Okay.
This exchange helps coordination, understanding the local context, and leads to more effective EPF compliance efforts overall.
Collaboration helps effective oversight. What about reporting industrial accidents? What's the procedure?
Reporting is based on 3 districts: incident, where it happened; coverage, where the establishment is covered for EPF; and resident, where the deceased's family lives.
Okay, detailed tracking.
The DNO in the incident district collects info under the RPFC OIC supervision and forwards it to the designated office within 3 working days. Ensures all relevant offices are informed for follow-up.
Detailed process for unfortunate events. The manual highlights closer scrutiny for manpower supply agencies. Why single them out?
Manpower agencies often have employees deployed across many client sites, making compliance tracking tricky. So the manual advises closer scrutiny of specific records.
Like what?
Things like their income tax returns, Form 27AS, Contract Labor Act, CLRA registration licenses. Para 5.7.1 lists relevant records. CLRA details, muster rolls, wage registers, returns to principal employers. Inspectors need to check these carefully.
Focused scrutiny for complex structures. What's the procedure if an inspector needs to seize records during an inspection?
If they find discrepancies or need records as evidence, they can seize them, but must follow procedure. Issue a formal seizure memo listing everything taken.
Right.
And crucially, prepare a panchnama, a written record witnessed by 2 independent people present during the seizure. There's a model seizure memo format in a separate SOP. Following these steps ensures legality.
Procedures for handling evidence legally. Can inspectors visit establishments outside their regular schedule?
Yes, but they need prior permission from the competent authority. Situations include an invitation from the employer or employees to clarify doubts, resolve compliance difficulties, or conduct seminars or workshops.
Educational visits too.
Right. After such a visit, they must file a detailed report within 5 working days. Ensures these activities are documented.
Documents educational outreach. What about timelines for completing inspections and uploading reports?
Strict timelines. Assigned inspections must be completed within 5 working days. The report must be uploaded to the Shram Suvita portal, SSP, within 48 working hours after completion.
So max 7 working days total.
Generally, yes. And they should issue a SNOT memo to the establishment rep during the inspection and give a copy to their office with their tour diary. Emphasizes timely action.
Tight timelines highlight focus on speed. What's the circle officer's role in reviewing these inspection reports?
The circle officer supervises and directs. They review reports from inspectors in their circle and decide on further action needed for any non-compliance found.
Okay.
Also, if an establishment refuses to produce records, the inspector reports it to the circle officer via e-office. The circle officer then processes the proposal for prosecution under Section 14 for that non-cooperation.
Supervisory and directive role. The manual details mandatory fields in Part A of the inspection report. What key info is needed there?
Part A captures basic identification, establishment's full name, location with photo, branch details, parent company info if any, and the nature of business linked to the correct NIC code or SSP classification. Foundational details for accurate records.
Standardized identification. What about Parts B and C?
Part B documents all records verified or collected during the inspection. Needs to be detailed, with collected documents hyperlinked in the digital report. Part C is where the inspector records findings on compliance, detailing any non-compliance or defaults observed.
Evidence gathered, then findings. What's the procedure for filing a prosecution complaint against a non-compliant place?
First, get sanction from the RPFC. Once sanctioned, file the complaint in the appropriate court within 7 days. No delays allowed.
Strict time frame.
Yes, progress of all prosecution cases must be monitored via a register. If more offenses by the same establishment are found later, a fresh complaint and sanction are needed. Rigorous process ensures proper authorization and tracking.
Proper legal process. How should inspectors handle complaints or info received from individuals about non-compliance?
Examine the details and evidence provided carefully. Then, cross-verify check EPFO records, maybe info from ESIC or GST authorities. If the complaint is about an uncovered establishment, the inspector needs to locate it, note coordinates, gather info locally, maybe from civic bodies. Proactive investigation to bring liable places under the Act.
Proactive investigation helps expand coverage. What vigilance is needed when dealing with closed or closing establishments?
High degree of vigilance needed. Recovering dues is much harder as assets might be gone or under liquidation. An IRP might be appointed, or CRP under IBC might be underway.
Complex situation.
Exactly. The inspector's role is crucial to safeguard member interests. Chapter 12 details their role in IBC processes, need proactive, informed action to protect funds in these vulnerable cases.
Extra vigilance needed there. The manual highlights tour programs and outreach activities. What's the rationale?
Tour programs approved by the controlling officer should balance field inspections, court appearances, office work, and include at least one fortnightly outreach activity, workshop, seminar, etc.
Outreach is mandatory.
Yes. The goal is to educate and assist employers and employees on EPF rules, promote awareness, clarify doubts, and foster better compliance. Outreach is seen as a vital part of their job.
Role extends beyond just enforcement. Finally, the manual stresses independence, impartiality, ethical conduct. Why is this so critical?
Absolutely paramount for maintaining trust with all stakeholders, employers, unions, employees. Inspectors are strictly forbidden from seeking or accepting personal advantages, financial or otherwise, like lodging or transport.
Avoids conflict of interest.
Exactly. High ethical standards ensure actions are unbiased, fair, transparent. This integrity commands respect and encourages stakeholders to engage confidently. Crucial for credibility.
Professional integrity is key. The manual lists relevant sections from the Evidence Act, Penal Code, and the new Bharatiya Nagarik Suraksha Sanhita. Why include these legal references?
These references on evidence relevancy, motive, expert opinions, admissions, document proof, false evidence, obstructing officers, misappropriation, breach of trust, arrest procedures, trial rules, give inspectors a foundation in the legal framework underpinning their work.
Basic legal knowledge.
Yes. They define admissible evidence, relevant offenses, and correct legal procedures for inspections, inquiries, and legal actions. Including the new Sanhita keeps them updated, essential for performing duties effectively and legally.
Equips them legally.
Yeah.
The manual also references other SOPs and FAQs. What's their purpose?
These SOPs and FAQs on things like member profile updates, freezing IDs, specific inspection procedures, provide detailed step-by-step operational guidance.
Practical help.
Right. They ensure consistency, clarify complex situations, provide ready answers to common questions, and standardize approaches. Practical supplements to the main manual.
Standardized operational guidance. Okay, let's turn to the Employees Pension Scheme, 1995, EPS, 1995, based on the pension manual. Sounds like a major document.
Yes, the pension manual is a huge undertaking. The acknowledgments mention extensive drafting, review, design efforts by many officers, guidance from CPFCs, current and former.
Wow.
It went through peer review by field officers, got feedback from all Central Board trustees, and was finally ratified and approved by the CBT in November 2024. This rigorous process underscores its importance as the definitive guide for everything EPS 1995.
That thorough process really highlights its authority. What key topics does it cover?
It covers a wide range: eligibility criteria for membership, details of all the pension benefits available, rules on contributions, the crucial process of actuarial valuation for fund health,
Okay.
specific accounting procedures for the pension scheme, and the organizational structure of the pension wing within EPFO that manages it all. A really holistic view.
A complete picture. How long does someone remain a member of the EPS? When does membership cease?
Para 1.3.7 says membership continues until one of these happens: reaching age 58, taking a withdrawal benefit if eligible, death, or when their pension vests, they start drawing it.
Right.
Para 1.3.8 adds you can carry over membership and service via a scheme certificate when changing jobs. But, crucially, if you take the withdrawal benefit, membership ends completely, can't be carried over. Para 1.3.9 touches on eligibility if coverage starts later than 1995, defines the membership life cycle.
Tied to active employment and benefits. Can members opt for pension before age 58?
Yes, Paras 2.6.4 and 2.6.5 detail the early pension option. Members can choose to start drawing pension anytime between age 50 and 57.
How do they opt in?
Indicated on the claim form, Form 10D EPS, but important, once you opt for early pension and the KPO is issued, that decision's final. No changes later.
Final decision.
Right, and Para 2.6.5 clarifies you don't have to claim it immediately upon leaving service before 58. You can defer the claim until any time between 50 and 57, offers flexibility.
A good window for flexibility. What if a member becomes permanently incapacitated while still working? Is there an invalid pension?
Yes, Paras 2.7.1 and 2.7.2 cover invalid pension. It's for members who become permanently and totally incapacitated, bodily or mental, preventing them from doing work they could do before.
How is that determined?
Usually based on medical examination. The pension amount is calculated using the same formula as the regular monthly member's pension. Para 2.7.2.2 says their service is counted as if they retired on the date of invalidation. Para 2.7.3 covers when it becomes payable, a crucial safety net for severe disability during service.
Very important support. The manual mentions dependent parent pension. Who gets that?
Para 2.12.2 explains this. If a member dies leaving no eligible spouse or children, a pension may go to their dependent parents. First preference is the father, then the mother upon his death, provided they were financially dependent on the member. Para 2.12.3 clarifies, if a member already drawing pension dies with no eligible family, the pension just stops. Para 2.1.44 handles a scenario where the member didn't have enough service for monthly pension but got a withdrawal benefit. There might still be family pension under Para 16b, extends support to parents in specific cases.
Support for parents in specific cases. What about children's pension? Who's eligible?
Para 2.12.5 details this. It's paid to eligible children of a deceased member. It outlines eligibility conditions and the order of entitlement if multiple children exist.
Different rules for disabled children.
Yes. Normal children typically get it until age 25 or marriage, whichever is first. Permanently disabled children unable to earn may get it for life, subject to conditions. There's a table showing scenarios. For instance, usually the first two get it until the second turns 25, then the third, if eligible, then the fourth. But if all four are disabled, they might all get it concurrently. A detailed framework for supporting children.
Thoughtful framework for children. The manual references circulars on things like withdrawal benefits, deferred pension increases, rounding off service. Why include these?
These circular references, listed on page 39, are important because they provide official updates, clarifications, and specific instructions on implementing EPS 1995 rules.
The practical details.
Exactly. They reflect refinements, address ambiguities, guide specific situations. Referencing them keeps the manual dynamic and ensures users have the latest official guidance on applying the scheme.
Keeps the guidance current. How is eligible service determined, and how is pensionable salary calculated?
Para 3.2.1 covers eligible service. It's basically the total service from November 16, 1995, or date of joining if later. There are specific rules for rounding off service periods, detailed in a No. 2009 circular.
Okay, and salary.
Para 3.3.1 explains pensionable salary. For service up to SEP 1 2014, it's pro rata, capped at Rs 6,500 month. For service on or after SEP 1 2014, the cap is Rs 15,000 month.
Okay, different caps.
Yes. And Para 3.3.2 handles cases where members weren't on full pay for the 60 months before exit. In that case, the average full pay during the 60 months when contributions were paid is used. Standardizes the calculation.
Standardized approach for service and salary. What documents are typically needed for pension claims?
Para 4.1.2 lists them. Usually a filled claim form 10D, online or offline. Correct bank details are essential. For family pension claims, the member's original death certificate is mandatory.
Oh.
Updated KYC and e-nomination details are crucial. Proof of date of birth for beneficiaries, birth cert, school cert, Aadhaar might be needed. Sometimes self-certification of the member's employment history. Specifics vary slightly by claim type, superannuation, early, widow, child.
Documents are key for smooth processing. The manual mentions proactive monitoring of upcoming superannuation claims. What does that involve?
Para 5.2 details this. ROs and DOs use a dashboard to track members nearing pension age based on DOB, joining date, and service length. Needs 114 months, 9.5 years. They then proactively contact these members via SMS, social media, email, webinars to ensure they know they're eligible and to smooth the claim process. Nodal officers also run workshops for staff to improve claim processing efficiency, shows commitment to timely service.
Proactive approach is good service. What about submitting the Digital Life Certificate, DLC? What methods are available?
Para 5.3 lists options beyond visiting an office or bank. Traditional biometrics, fingerprints, are one way. Another, increasingly popular, is face authentication technology.
FAT.
Face authentication. Yeah. FET makes it much more accessible and convenient. Pensioners can submit their DLC from home using a smartphone or tablet, no need to travel to a bank, post office, or common service center. EPFO provides guides on using FAT and sends SMS reminders before the DLC due date. Digital methods making it easier.
Digital tech making things easier is great. The manual mentions accepting employer requests for higher pension based on the Supreme Court judgment. What's the process there?
Para 5.6.10.1 says request undertakings from employers, under Para 26.6 computes, for contributions above the ceiling can be submitted any time before the higher pension is granted, following the No. 4/2022 SC judgment. This applies to exempted establishment employees too. Para 5.6.0.2 notes grievances on this are tracked under a specific higher pension category. Para 5.6.10.3 says these are mainly handled by the nominated officer. And 5.6.0.4 mentions regular monitoring by ROSO OICs to ensure timely action. So they're actively processing these requests.
Actively processing based on the SC order. How is the actual pension amount computed? Main factors.
Para 5.7.1 states computation follows the EPS 1995 scheme rules strictly. The formula uses two main factors: pensionable salary, average of last 60 months' wages, subject to caps, and total pensionable service, years months contributed. The scheme's formula uses these to get the monthly pension.
Define formula using salary and service. What documents are needed to validate the option for higher pension?
Para 5.8.1 lists them. Detailed wage slips submitted by the employer with the validation application. Other authenticated salary slips or employer letters might be needed.
Okay.
A copy of the joint request and undertaking from employer-employee is crucial. Any PF office letter before November 4/2022 showing contributions were made on higher wages is also needed. And the member's PF account must be fully updated with interest and their UAN Aadhaar seeded for central processing. Comprehensive documentation for verification.
Specific documents needed for validation. How can members or beneficiaries actually submit pension claims?
Para 6.1.1 gives options. Preferred is online via the member portal or the Uming mobile app. Alternatively, offline using physical forms, per Para 4.1.2, submitted by post or in person at the EPFO office. Both online and offline channels offered.
Both digital and physical options available. When processing offline claims, what key things do EPFO officials check?
Paras 7.1.4 and 7.2.4 list scrutiny points. Check composite claim form is signed by claimant, attested by employer, unless exempt. Purpose of claim clear. Service DOB details correct. Any suspicious overwriting cutting.
All right, basic checks.
Bank details accurate and match records. Attached bank passbook copy or canceled check. Proof of age for beneficiaries valid. Bank account suitable for pension payment. If precept 2008, check commutation option. For disablement pension, ensure disability occurred during service. Comprehensive checks for accuracy and fraud prevention.
Detailed checks for offline claims. How is pension actually disbursed once approved?
Chapter 8 covers disbursement. RPFCs arrange with scheduled commercial banks to disburse monthly pension, commuted value, return of capital. Choice of bank depends on pensioner needs and bank reach.
Okay.
Field offices ensure credit to pensioner accounts by the last working day of the month. The pension branch coordinates with banks, monitors statements, reconciles accounts, aims for timely, secure delivery.
Timely disbursement is critical. How are undisbursed pensions handled? And recovery of overpayments.
Para 8.4 deals with undisbursed amounts, example, wrong bank details. Pension branch tracks these, contacts the pensioner, may require in-person KYC at the bank to release arrears. Para 8.5 covers overpayment recovery. Action starts immediately upon dejection. May involve debiting the bank account or recovering from other payable benefits. Pensioners usually give an undertaking allowing this at the start, handles errors and arrears.
Procedures for undisbursed and overpaid amounts. The manual mentions family pension entitlement. How is that determined?
Para 8.6 says the pension payment order, PPO, issued to the primary pensioner will also state the family pension entitlement for eligible family members after the pensioner's death. The main EPS 1995 regulations detail who qualifies, conditions, and amounts. The PPO documents this future entitlement.
Continued support for family is key. The manual discusses actuarial valuation. Why is that important for the pension fund?
Chapter 10 stresses its importance. Actuarial valuation is a periodic check of the fund's financial health and long-term sustainability.
Like a health checkup for the fund.
Exactly. It analyzes contributions, benefits paid, demographics, mortality, life expectancy, future liabilities, helps determine if current contribution benefit levels are sustainable, informs potential adjustments, guides investment strategy, ensures compliance with financial regulations. Table 2 summarizes historical valuations, crucial for long-term solvency.
Vital for long-term financial health. The manual mentions restoring normal pension after 15 years for those who commuted before a certain date. Explain that.
Para 10.3.1 addresses this. It's for members who commuted part of their pension under the old Para 12A, specifically on or before Sep 25, 2008. For them, their full original pension amount is restored 15 years after the date they commuted.
That's significant.
Yes, it was based on actuarial assessments and seen as enhancing benefits for early commuters, a significant plus for those eligible.
Good benefit for those early commuters. Finally, on pension, the manual details the pension wing structure at head office and its functions. Why detail that?
Chapter 11 outlines the HO pension wing structure. Figure 20 shows it visually. Details key verticals: policy and legal, operations, grievance management, and the functions of sections within them.
Like who does what?
Exactly. Who handles policy changes, legal matters, central processing like higher pension claims, grievance redressal, general admin. It provides clarity on responsibility, workflow, and how the scheme is managed at the top. Helps transparency. It also briefly covers field office workflow, a Cocofins pension branch coordination, IDS use, pension branch duties, disbursement, bank coordination, records, and dashboard monitoring for pension EDLI claims.
Understanding the structure gives insight into the admin backbone. Okay, final area. Recovery of dues from the Recovery Manual. Crucial for financial integrity.
The Recovery Manual details procedures for the recovery officer to enforce recovery certificates issued under Section 8C of the Act. It starts with formally notifying the defaulting employer and other recovery officers if assets are elsewhere, ensuring coordination.
Coordinated effort. What main methods can the recovery officer use?
Primarily attachment and sale of the defaulter's movable and immovable property. This includes agricultural produce, negotiable instruments, property in court custody, shares.
Wide range of assets.
Yes. There's a process to investigate claims against attached property. The officer can also issue prohibitory orders preventing the defaulter from disposing of assets. Powerful tools to secure the dues.
Significant powers. What are the rules for selling attached property?
For immovable property, a formal sale proclamation is prepared in the local language after notice to the defaulter. It must specify time, place, property description, known encumbrances, and amount to recover. The manual details proclamation contents, timelines, sale conditions. For movable property, if custody costs might exceed its value, the officer can sell it immediately. Aims for a fair, transparent disposal process.
Rules ensure fairness. What if a receiver is appointed to manage attached property? What are their duties?
The receiver takes possession, manages the property, collects rents profits, and applies funds as directed by the recovery officer.
And if the receiver messes up?
If they fail to pay amounts ordered, the recovery officer can recover from the receiver's security deposit or by attaching and selling the receiver's own property, ensures receiver accountability.
Accountability for the receiver too. Yeah. The manual references circulars on recovery. What extra guidance do they provide?
These circulars offer detailed instructions, policy guidelines, best practices on recovery. They address specific procedures, clarify rules, emphasize proactive, timely action. They supplement the main manual.
Okay.
The manual also includes sample forms like prohibitory orders, CP4, warrants of attachment, CP5, notices for settling sale proclamation, CP17, practical tools for the officers.
Sample forms provide practical tools. What powers does the recovery officer have under Section 8F specifically?
Section 8F grants broad powers to recover dues from a certificate. Includes attachment and sale of movable property. Under certain conditions, arrest and detention of the defaulter in civil prisons.
Serious powers.
Yes. Appointing a receiver for attached property. And a general clause allowing any other recovery mode prescribed under the Act rules. Extensive powers for effective recovery.
Extensive powers indeed. Lastly, issuing notices to people who owe money to the defaulting employer. What's the purpose of that?
Section 8G allows the recovery officer to issue notices to third parties who owe money to the defaulter. The notice requires them to pay that amount directly to the CPFC, or authorized officer, up to the employer's total EPF liability.
Garnishing debts.
Essentially, if the third party pays the defaulter after receiving the notice, they become personally liable to EPFO for that amount, up to the EPF liability. Failure to comply can make the third party themselves a defaulter under the Act. It's a powerful tool to tap into funds owed to the defaulter.
Valuable tool to access third-party funds. Wow, that was an incredibly thorough deep dive. We covered a massive amount of ground.
We really did. We went through audits, communication, compliance, legal stuff, the EDLI scheme, the main EPF scheme, employee info and grievances, exemptions, the inspector's role, the pension scheme, and finally, recovery procedures.
It gives such a solid foundation for understanding just how much the EPFO does and its absolutely crucial role in Social Security for so many people.
Absolutely. And thinking about that vast scope, the millions of stakeholders, it raises a final thought for our listeners. Considering everything we've discussed, what do you see as the biggest challenges and maybe the biggest opportunities for an organization like the EPFO in the years ahead? Navigating the changing economic and social landscape. It's worth reflecting on the complexities of managing such a vital system.